Software patents are among the most difficult of all patent applications to get allowed. There are some patent examiners who hardly ever allow software patents. In this video, I'm going to share with you my secrets for getting software patents granted. And for starters, when referring to your new software invention, don't refer to it as a software patent. You need to speak in code. Hi, my name is John Farrell. I'm a Silicon Valley patent attorney. Welcome back to my channel. It's no lie that in the past 10 years, it's been pretty difficult getting software patents allowed in the patent office. The problem started with a 2014 Supreme Court case of Alice Corp versus CLS Bank, in which Alice Corp filed patents covering the verification by computer of bank payments. Now, prior to Alice's patents, this process had been going on in banks without the use of computers for more than 100 years. But it was the verification of the payment by a computer which was determined to be allowable subject matter in the Alice patents. The Supreme Court said these patents were not allowable because the subject matter was too abstract. That is, the idea of verifying a payment was well known, and merely adding a computer to verify the payment was not sufficient to arise to the level of patentability. Now, the patent problem that was being addressed in the Alice decision was really a problem that arose in the late 1990s under a number of federal circuit cases that were very permissive with respect to patentability. And these decisions, combined with the Clinton administration's liberal view on software patents during the .com era, led to the proliferation of a number of patents that probably should never have been issued. Some of the ideas that were the subject matter of patents during this period included the alphabetizing of a mailing list using a computer to buy and sell stocks, organizing a Dutch auction on a computer, and probably thousands more. The problem that was created was that inventors were merely taking well-known ideas, using a computer to implement these ideas, and filing blocking patents on the use of these ideas using a computer. Consequently, even the simplest of processes in many cases were being blocked by trivial patents. And in much the same way that the .com bubble was really a land grab in which entrepreneurs took brick and mortar businesses and implemented them on the internet, there was a rush to the patent office to file patents on these otherwise well-known ideas. This proliferation of really basic and fundamental patents led to the creation of a cottage industry in which enforcement companies sprung up, bought up some of these unused patents, and began broadly enforcing these patents against existing businesses. Expensive to fight in court, these companies that were being sued for patent infringement on these frivolous patents would often settle for 5 or 6 figure sums just to avoid expensive patent litigation and the prospect of potentially losing their case in court. These enforcement companies came to be known as patent trolls and were thought by many to be stifling business growth and true innovation. And so with this as a backdrop, in 2014, the Supreme Court stepped in with the decision in Alice versus CLS Bank to try to eliminate these frivolous abstract idea patents. And in doing so, they developed a somewhat complex two-part test for determining whether an invention was patent eligible. Now, in its simplest form, the two-part test first checked to see whether the subject matter of the invention was itself patent eligible. That is, was it merely a mathematical algorithm or a law of nature or some other idea that just clearly wasn't patentable? And the second test was looking at the claim elements individually in an ordered combination. Do the claims become or transform into patent eligible subject matter? Now, in many respects, this was a baffling test, not only for inventors and their attorneys, but also for the examining corps in the U.S. Patent Office. In the early years following the Alice decision, the Patent Office seemed to really tighten down, finding abstract ideas in almost every software patent application that was being submitted. It was really difficult during these dark days to get a software patent application allowed. Fortunately, in the Patent Office, the interpretation of the Alice case and the application of the two-part test in examining patents has relaxed quite a bit. But we did learn a lot of lessons about how to optimally and efficiently file patent applications and write patent claims related to software patents. And I want to share with you a couple of ideas that I've learned and I've applied in the patent applications that I've worked on. To begin with, when writing the patent application and thinking about the software invention, it's really helpful to think of a general purpose computer as being specialized or defined by the software steps that are programming the hardware. For example, the software may identify a certain section of computer memory to open or create a database, and that database is used to receive information, to send information, and to store calculations. So I think it's important to reference that specialized hardware when thinking about the steps of the computer application. Likewise, there may be calculations in the software that create special processes in the hardware, and being able to identify these processes and tie them to the specific hardware is really helpful in mechanizing the program and making it feel a lot less abstract. Think of your software program as a customized machine rather than just an abstract sequence of code. Another tip I can share is that I try to emphasize the value and advantage of executing the process on a computer. That is, the software program does things using a computer that only a computer can do. An example of this is detecting malware on a network. Only a computer can really be used to detect computer malware. This explanation reinforces the idea that this is more than merely just an abstract idea being implemented on a computer. And a tip I've shared in others of my videos, I think it's very helpful when you can find a feedback loop in your software program. That is where a data set or a prior result is used in creating a new result. And that new result then is used to update the data set and used in the next calculation. That is, calculations continually improve because of this feedback loop. This really is the basis of learning systems and artificial intelligence systems, and I found these elements to be highly patentable. Now, if you found some of the ideas in this video useful, I know you'll find this next video on software patents helpful as well. Thank you so much. See you in the next video.